17, oh, you are a traitor. They'll think like that. This is the way people are going on. So it has to be, all these things have to be thought of. Unfortunately,
if you say so, yes, all these our missionaries have won their interview hills. Despite all the difficulties, I'll agree. I will also say, okay, you please, Christians, please leave. You don't allow them to do so.
Yeah.
Neither you yourselves are ready to go there. You want them to rot inside a jungle. Then no, this and that, and we again diverted. But then the basic, that is one thing is that this is not only politicians speaking. What I noticed, is the army.
yes,
Which is supposed to be absolutely secular in their approach. And that is the kind of a brigadier he's saying to his CO is sitting there, and what message he's giving to his COs.
yes,
And that was in 1987. Just imagine.
Yes.
Today, I'm not talking of today's time.
Today, yes, even at
I'm
that
talking
time.
of 87. This thing happened. Of course, this thing did not strike me at that time because now I realize that what they have done to the Indian Army also. Therefore, I would not be very surprised if the Indian Army today, what they are doing today in Northeast or for that matter in Kashmir or in other part.
Yeah.
If you don't subscribe to this mainland
Yes.
nationalism, you don't have enemy.
Yes. Kind of, yes.
That's very
tragic. They are trying to create this all over. Subtle, it's openly going on now.
Yes. Sir, open-ended.
Sir,
we conclude very
I would like to put one question, sir.
Ah.
Sir, actually, for the last 2 days, you have been making spot inquiries and making assessment of the gross human rights violations in the state that perpetrated by the armed forces, its elites, and that's become evident that under the Special Power Armed Forces Special Power Act. Sir, how do you finally ascertain? Finally ascertain that what is the real cause of such perpetration, and are you certainly sure that just removing the Armed Forces Special Power Act can ensure the lasting peace in the state?
I'm not talking in terms of peace.
Sir.
That's why I'm not talking in terms of politics.
Sir.
I'm talking only in terms of human rights violations.
Sir.
At the moment, my inquiry is confined to human rights violations.
Okay.
And there's a fear here, and that fear has resulted in violation of human rights. You're not sure what is going to happen to you next. You're not sure whether the child will come back. You're not sure what is good when you go out. You don't know what's going to happen. Now that is certainly not conducive to any human rights, human dignity, your own dignity. A core of human rights is human dignity. Now that you are not sure. So I'm only trying to say, well, this is what I see here by meeting people, talking to people, by going through the cases that are brought before us. I don't know I'm not concerned with politics, how peace will be maintained, peace will not be maintained, I don't know. I'm not going to say anything about it. It's not my job.
Sir, and another thing, sir. Would the National Human Rights Commission and State Human Rights Commission and at the same time state government and central government, they fail to abide the instruction, recommendations given directed by the Amnesty International that affects the human rights body. And at this stage, at this juncture, how can you guarantee that the gross human rights violations in the state can be totally averted?
At this juncture?
At this juncture, present juncture, how can you guarantee that you can avert such a situation, such kind of violation in the state?
Avoid what situation?
Such kind of human rights violations.
How to avoid? Today by public awareness. Telling people, organizing people, organizing support systems, like your Mira Paibi. There is no better example than Mira Paibi. They are doing the work of human rights defenders. The best human rights defenders here, as I can see, is the Mira Paibi. They are doing that kind of work. So that is the one thing we have to build up. Wherever possible, we have to build up that.
So my friend comes from the Imphal Free Press.
Okay.
And he's following our whole thing most
I know.
meticulously from all the
this is what I'm trying to say.
Like other journalists who comes and goes, he's
my last question, sir. And my last question, sir.
This inquiry which we are doing, for what purpose? Not that the government will accept it. I don't have any hopes. But I'm sure public will have some idea of what you have done. Public will come to know of it. There will be sort of be the part of right to information, right to understanding. So this build up public opinion, public awareness, and we send it to the government, send it to central government, send it to National Human Rights Commission, send it to Amnesty International, wherever possible we can send it. And they will all know what's happening. They will all ultimately bring pressure on the government. Okay, this can't go on.
So there are certain developed powerful countries like USA and certain Western countries who are totally who are indulging in participating or taking active interest in any human rights violation that's detected any parts of the globe, particularly countries like Burma. And suddenly that human rights violence in Burma cannot be much worse than the violation prevalent out here.
I know that.
And how can, sir, is there any possibility of inviting the USA government or any agencies out here
that again is not our job. We are not doing that. As on behalf of the People's Human Rights Group, I will say we are not doing any such thing because we don't invite the government. We have nothing to do with that kind of thing. But I tell you, what we did in Burma, I headed a small international team based, there's an Asian Human Rights Commission in Hong Kong. I'm a part of that. And so they organized a team. I headed a team, one professor from Thailand and one from Cambodia. So we came to the border of Burma and Thailand, a place called Meson. We have large number of refugees, 150,000 refugees from Burma are there. And they are all, they have come there because they are denied right to food. So our inquiry was confined to right to food, denial of food, food scarcity and militarization. They all suffered for want of food because of militarization. So how far militarization has denied right to food? That was the scope of inquiry. So we brought a report. I can give you a copy of that. I brought a report on that. This report, as a human rights group, what we did, we sent to the United Nations Human Rights Commission. So after a bit of lobbying, we got an audience. So one of us went there about last April to Geneva. So this report, we got the chance to present the report and explain as to what has happened here within Burma. As a result of that, Burma government was called upon to answer. So now this bit of Burma government was made to take note of what we did. And of course we hope things will improve. This is what we are trying to do. Ultimately, all those rest of things we are not doing.
Yeah, we have a copy of this report for the Hungry Nations.
Yeah, Voice of Hungry Nations, I think you're going to come.
That's Chechnya.
Yeah, it has come in the website, in the net also. Yeah, it has come.
In your website, which
yes. The Asian Human Rights Commission has its own...
It must be Asian Human Rights Commission.
AHRC. You'll get it. But anyway, we got. I can send a copy of it.
We have a copy. We can share it actually.
Yeah, certainly.
If we have more copies, of course we can share.
It's well documented. We got. See, there's a small group called Burma Issues. They and Asian Human Rights Commission jointly organized this, and they invited me for a public hearing. We went to the border, sat there for 4-5 days, talked to people, recorded statements.
In fact, here also there are some Burmese students who have fled, and our brother Koteshwar is one of the first lawyers who have moved to the court, and initially they were arrested under Foreigners Act. And through the legal intervention they were actually released, and they said that they have fled the country on fear of persecution and they should be treated as refugees and not as...
about this refugee status. Some of them staying here right now. Many of them have gone to abroad also. America.
But what was interesting was, on the Thai border, there's a lot of investigation done, which is the eastern border. On the western border, there's absolutely nothing. For example, the situation
your
in
border, I think I don't know.
Yeah.
Burmese are there?
Yeah, of course. Burma is complete. The whole northeast is basically Burmese border.
Okay.
Even though in Manipur there is some civil liberties groups who help here and there, in Mizoram the situation is very bad. I mean, there's no civil liberties movement. The Chins, number of Chins has been literally thrown out because they don't want Chins to come into Mizoram. Whereas there was a lot of counter-insurgency operation in the Chin state, and as a result of it, a lot of Chin has gone in. So this is also an issue, and even the UNHCR is not given permission to come to the northeast, which is very interesting. Whereas in the Thai border, there's so much of activities, there's absolutely nothing going on this side of the border. And you call India the largest democracy in the country, and Thailand is a... I mean, this openness is not here.
You know why? Yes.
Amnesty has tried several times to come here, but they haven't refused permission.
Okay, Amnesty will refuse permission.
This is perhaps the first proper...
Till Calcutta they allowed, till the end of the mainland they allowed. Calcutta.
Then the jungle starts.
That's why they resisted here. Very
Microphone.
3 days, the People's Independent Commission of Inquiry has been making full visits, seen many of the reports which has been made on the issue of the human rights violations by the armed forces under the shadow of Armed Forces Special Powers Act. First 2 days was basically field visits that we have conducted in various spots where we examine witness, record their statements, and also give certain suggestions as to where we can go ahead. The second day, 2 was basically field visits, and we have covered basically tortures, cases of torture cases of revenge killings, cases of disappearances, cases of rape, and yesterday we examined the reports which are present in Manipur as a result of the armed forces atrocities. We also had a roundtable discussion yesterday with experts who have been working on the field of human rights in Manipur, and many important suggestions have come up. The press have widely reported this matter, and today we are going to, as we have planned, we are looking forward to a workshop of lawyers wherein we can discuss many of the problems, the legal issues where the lawyers are confronted while trying to take up cases and defend human rights. Once again, I heartily welcome all of you who have spared your valuable time to discuss an issue which is becoming very, very important for the people of Manipur in particular and the people in under disturbed area in general. Welcome all of you, and I hope you have a very productive and fruitful workshop today. Thank you very much.
Thank you, Mr. Bablu Rotongam. Next, I call upon Mr. Colin Gonzalez of the Human Rights Law Network to give keynote address. Mr. Gonzalez.
Introduction at this stage. I just want to say that this morning we went and met a judge from Manipur, who is now the assistant session judge. I don't want to mention his name because he spoke to us confidentially. And in 1989 he was the CJM in Manipur, in Imphal. And what he told us this morning is perhaps something that we can all keep in mind and remember as to the state of affairs in the city. He told us that he was picked up and tortured, a sitting judge, by senior officers, a brigadier, a colonel, a major, and a captain. And he was tortured because he was a Naga. There was some Naga underground had robbed the bank. He was a Naga judge. So they picked him up, tied him to a chair, and tortured him with electric shocks on his abdomen. And the shocks were so severe that in struggling, he broke his chair. He went to the High Court and complained. The High Court discontinued its functioning for that day. All the judges of the High Court assembled. He gave his story. An inquiry committee was ordered. And the inquiry committee gave its report in 1995. Until today, that High Court report is pending in the High Court and his case has not been heard. It is a tragedy of justice in this country and the state. that a sitting judicial officer can be tortured by the army. The report can be filed in 1995 in his favor. Until today, no action has been taken. I don't want to say very much more except to say that we have learned very much from the stories and the accounts of the persons present. We have learned a lot about the situation in Manipur. And I would say that you lawyers and you social activists in Manipur are actually heading a human rights movement. You are at the mainstream, you are at the head of the human rights movement. Thank you very much.
Thank you, Mr. Colin Gonzalez. Next, I call upon Sri L. Nandakumar, Senior Advocate, to present the papers on Abuse and Existence of Armed Forces Special Powers Act 1958.
Chairman, my friends, I'm going to present this paper. It's not paper, I have done some exercise project the moment I was off from this one. In this chapter, I am going to present a brief sketch about the original and important human rights. Discuss about the violation of human rights by the armed forces of the United States police forces and the remedies available to the victims of violation of such rights, and responsible society when violation of human rights occurs in society. Human rights that back to the very dawn of the human civilization, a close study of evolution of human rights, a trace of history from the ancient times. One will find that Middle Ages human rights and practice stood at a low ebb till the beginning of modern history. But recognition of human rights started taking place with the passing of Bill of Rights 1698, followed by American Declaration of Independence of 1766, French Declaration of Independence 1799, enactment of anti-slavery laws in 19th century. Concerning the Constitution of India, recognition of human rights will be found in the preamble of the Constitution, and protection of such rights have been clearly provided by Article 21 of the Constitution of India. Value and importance of human rights have been judicially recognized by canteen of decisions of the Apex Court, and such rights provided in the form of Article 21 of the Constitution of India have been held as one of the basic structure of our Constitution by the Supreme Court of India. In Indrasingh vs. Delhi Administration in the year 1970, Supreme Court 1091, Supreme Court of India upheld the human dignity, went to the extent of saying that the spiritual basis of our constitutional order is human dignity, social justice, not sadistic cruelty of hard enforcement of the one end. In Tori, George Bargis vs. Bank of Fortune, year 1980, Supreme Court, Porcelain, Managed Judges said, high value of human dignity, word of human person, enshrined in Article 21, right to Article 14 and 19, obligates that not to interfere except under law which is fair, just, and reasonable in its personal actions. In Sunil Bhattar's case reported in the year 1978, page 1675, Supreme Court held that fetters, especially bar fetters, shall be summoned as violating human dignity. In Dandari Satpathi's case, year 1978, 1025, Supreme Court observed each individual accused, included by virtue of his guaranteed dignity, has a right to a private enclave, where he may live a free life without overbearing investigatory engagement or even crypto-policing. In Kishore Singh's case, reported in 1981, SC 625, Supreme Court declared that human dignity is a dear value of our Constitution, not to be bartered away for bare granted by their officials. In spite of all importance and values of human rights found in the history of human human rights, tracing from the origin of human civilization till the advent of the present-day society, and in spite of the declaration of the importance of such rights by World Community Organization and by Cantina Judicial Decision of the Apex Court of India, some of which are quoted above, such rights are violated by state agencies such as police force, armed forces of the Union, who are assigned the duties of protecting the human rights and amongst other duties. World Community and the Supreme Court of India have viewed such violation of rights seriously. Justice Krishna, in the case of Kishore Singh versus State of Rajasthan here in 1981, SC 625, expressed deep concern regarding police cruelty. No police lifestyle which relies more on fist than on which on trouser more than on culture can control crime because of means of Bombay on the ends of refuel the fires which it seeks to extinguish. Secondly, state must re-educate the constabulary out of their sadistic urge and incorporate respect of human person, process which must begin more by example than by precept if the law runs are rarely used. Nothing is more cowardly, unconscionable than a person in police custody being beaten up, and nothing inflicts a deeper wound on our constitutional culture than a state officer running this path regardless of human rights. We believe the basic pathology which makes the police cruelty possible will receive government serious attention. Who will police the police? What psychic stress and social deprivation of constabulary's lifestyle with corrective healing? When will and which not case become a police case? When will the roots of the third degree be plucked out and the fruits of humanist respect put out? In the background of the importance of the human rights and depreciation of the various forms of cruelty committed by the armed forces and police forces, a special law called Armed Forces Special Court Act 1950 was enacted, introduced, empowering the armed forces of the Union certain powers specified in Section 4 of the Act. In this context, it is to be noted that such powers are delegated to armed forces of the Union who are not properly oriented to deal with such situations. Armed forces of the Union consist of the Army and other forces of the Union such as Central Reserve Police Forces, Assam Rifle, Border Security Forces, etc. Forces of Union were organized for different purposes, though personnel of the forces could be utilized in that of civil administration in the area specified in the Act. Such forces have not been properly trained to deal with human problems arising in the different contexts of the society, which requires a delicate handling of the situation. Abuse of the provisions of the Armed Forces Special Power Act, exercise of such power and access to the power conferred by the provisions of the Act are not uncommon in Manipur. Abuse of powers conferred by the armed forces of the Union occur in different forms, such as confinement in their custody beyond the period provided in the Act, and the Constitution of India, inflicting all sorts of physical and mental tortures while in their custody under the purported guise of extracting information and interrogation of detained persons without referring to law. In the aforesaid acts, all the aforesaid amount to abuse of powers conferred on them by the provision of Armed Forces Special Power Act 1950 or exercise the power in excess of the powers delegated to them. Detention of arrested person hours beyond the prescribed period of detention, interrogation of the detained or arrested person amounts to exercise power by the armed forces in excess of the power conferred by the Act. Section 4 of the Armed Forces Special Power Act 1950 provides that any commission officer, warrant officer, non-commissioned officer, or any other person of peculiar rank in the armed forces may, in the district area, exercise the power provided by Section 4A to 4D of the Act. Section 4A authorizes a forces person to exercise power of firing upon or otherwise use of force even to the extent of posing that against any person who is found acting in contravention of any law and order for time in force in disturbed area, and prohibit the assembly of 5 or more persons or carrying of weapons or of things capable of being used as weapons or of firearms in the single course of self. Exercise of such decorum power is subject to the formation of an opinion by the concerned person that there is a necessity for maintaining public order. Formation of opinion that a person against such power is to be exercised in a district area, rejecting in contravention of any law and order for time enforced in the district area. Concept of maintenance of public order is highly abstract one. Similarly, public order is also equally an abstract one. Maintenance of public order may vary from time to time, circumstance to circumstance. Similarly, contravention or non-contravention is to be tested under different circumstances and different contexts. What is law, which is set during contravention for the purpose of exercise power, have not been clearly specified in the Act. A non-commissioned officer cannot be expected to know the abstract meaning of public order, acting in contravention of law and order, when the majority of armed forces of the Union are not trained in the line for dealing with human relations with the society and their interrelation between them. Armed forces are empowered to arrest any person who has committed a cognizable offence against a reasonable suspicion exists that he is about to commit a cognizable offence. The word cognizable offence has got a legal meaning. Same is defined in criminal procedure code. Armed persons, especially non-commissioned officers, who are mainly recruited from the lower rank, are not expected to know the difference between cognizable and non-cognizable offences. The power delegated to them by the HRLN is abused. Section 5 of the Armed Forces Special Power Act mandates that any person arrested, taken into custody in exercise of the power conferred by the Act shall be made over to the officer in charge of the nearest police station with least possible delay, together with a report of the circumstances occasioning the arrest. I don't find any problem in the Armed Forces Special Power Act 1950 empowering armed forces to interrogate any arrested person except handing over the person to the nearest police station in a manner provided by Section 5. But we find the army personnel and paramilitary forces are interrogating the arrested person without any authority law, using third-degree method while in their custody for the purpose of extracting from leading to serious violation of human rights. This is a clear case of abuse and excessive exercise of power conferred by the state. Abuse of power, exercise powers, exercise in excess conferred by the Armed Forces Special Power Act are not uncommon in Manipur. Such violations, abuse and exercise in excess of the power by the armed forces are so rampant in Manipur. Not to speak of abuse of such power by non-commissioned officers, abuse of such power by commissioned officers, even against the judicial officer in Manipur, are brought to the notice of the government. The judicial magistrate Tamerong District Manipur was taken into custody by a commissioned officer at the behest of a brigadier operating power. He was detained and physically tortured by giving Alex Usop. Matter was brought to the notice of the High Court. An inquiry was conducted by sitting judge of the High Court against such commissioned officer. If such violation or abuse of power could be committed by a commissioned officer against a judicial officer of the state, one could imagine the gravity of the abuse of powers that could have been committed on innocent civilians residing in far-flung area of the state. Even there are reports that Sanakul personnel such the residential quarter the sitting judge of the High Court at Dimapur, thank God for the justice and condone their activities on unconditional authority rendered by any officer to the honorable justice. Abuse of powers of the Act 1950 causing disappearance of person taken into custody by the armed forces were brought to the notice of the High Court by habeas corpus petition filed in early part of 1981 for the first time. The case went up to Supreme Court. Habeas Court directed has been filed to investigate the case. A compensation of the rate of rupees 1 lakh back to and were ordered to be paid to the members to the mothers of the disappeared person. In the fact of the case, there was some mistake there also titled. Fact of the case registration is not yet known. Similarly, in the beginning of 1982, CRPF personnel apprehended from his house. His whereabouts is not yet known to the family members. High Court issued a case ended with payment of 2 lakhs to the family members of the disappeared person. Recently, we come across physical torture and elimination of various persons by the armed personnel of the Union in alleged encounters according to the persons of the armed personnel. Genuineness of claim are to be tested and examined judicially. So far, I know all the commissions appointed under the Provisional Commissioner of Inquiry in 1952 involving army personnel of the Commission found abuse and excessive powers by the armed forces. A great number of such cases are pending before the High Court. In great number of cases, compensation have been awarded by the court, where arrested person disappeared after arrest by the army personnel. A remedy is available through the intervention of court, having availed in a great number of cases with the help rendered by various organizations working on the question of violation of human rights and human. Such remedies are not sufficient enough to prevent such abuse and excessive exercise of power by the armed forces. Supreme Court in the cases of Sebastian M. Hongri versus Union of India 1981, SCC have issued number of dons and do's and don'ts. The same have been brought to the notice of the possibility of the armed forces tribunal and step police. In spite of such guidelines for exercise of power by the armed forces in order to prevent violation of human rights, abuse of power by the armed forces by the apex court and the case referable, violation of such rights, guidelines are brought in daily papers and notice of the court by several appropriate petitions before High Court. I wish to press on the court that in such then problem faced by the present society in Manipur cannot be solved by the use of armed forces of the Union by invoking provisions of the Armed Forces Special Power Act. Since then, the Armed Forces Special Power Act 1950 to deal with the insurgent problems of Manipur, issue has been aggravated instead of controlling the same. Situation may arise one day that a problem as on today may go beyond the repair causing enormous strain on the society. Thus, society has a role to play in preventing deterioration of the situation. Absence of sincere efforts by the politician power problem to be solved. I would like to make an appeal to all citizens of Manipur and organizers of voluntary organizing working in the field of maintenance of human rights and dignity. Efforts should be made to incorporate right to live with dignity in a society is a fundamental right. Such right cannot be deprived of by state authority except according to the procedure established by law. No person when arrested shall be detained in custody without being informed of the grounds of such arrest. He shall be produced before the nearest magistrate within the period of 24 hours of such arrest. Make the public aware of the do's and don'ts or guidelines issued by the Supreme Court of India. Government should also see that strict observance of the guidelines in order to prevent violation of human rights of the by the armed forces while operating the field in act of civil authorities. Thank you very much. This is the topics I present today in this workshop. Any member who want to discuss whether I take up these issues after this or after my friend take up on the second
Excuse me, sir. I'd like to one question that in this pandemic situation in Manipur, the most difficult thing is an advocate to handle is that when a person approaches me with a report that his nearest case has been arrested by the security police. So what is the first step I have to do as an advocate and to advise to my counsel to my client? So what is my first step to do it? If the person has been arrested by security forces, without issuing or issuing an arrest name, what's the first step? I'm saying that the security forces means Union of India, not the security forces.
Security forces of the state or first special depends from case to case, from text to text. The moment you come, a person comes at a late at night and reported to you, sir, my son has been arrested into custody by the armed forces late at night. And what is the remedy available to me? And please help me. Because a lawyer cannot be expected, cannot go at that time, cannot be expected to make an inquiry to the army authority because of the prevailing law and situation in the state, as of today. First step is just when they see that you file a representation to them and how they immediately an alleged possible. Because by the time when you are approached at that time, you may not be in a position to approach the court also, because it takes its own time to prepare the case in a proper form and ask and make a decision. Just you have to advise your client that make a representation and inform the authorities, the police authorities, if it is an armed possession unit, that person they have been taken into question. Please see that this is the thing. And over and above that, my personal experience has come across, even though a person is taken into custody and submitted application by the members of the family, and the police, because one cannot go and expect in this court and back and inquiry in this chapter and how the organization is being set up by them who is not go, the public to go. And normally we used to go to the police, or if not, to the local MLAs, politicians, just to help them. And police will say, instead of inquiring the tragedy in Manipur, instead of inquiring, helping this man when such action is taken, and then if it is handed over within the nearest possibility. Suppose if it is case taken within Imphal, nearest police station is Imphal police station or local police station, next day they can hand over the job. They go on detaining and just police also could not help us. There is the tragedy. Ultimately, we have to approach the court with sufficient material. This is the thing what actually we can help and render to the parties and the parties who are taken into. If it is not given handed over to police within that stipulated time, you have to approach the court for a habeas corpus. But in some cases, I have come across from my personal experience, court directing the army authority to hand over to the police. That theory also, in some appropriate case, we have to test the correctness of the decision. Directing by the court to the army authority to hand over to the police station. When we came and complained that we had been detained for more than 24 hours, that direction also I have very great doubt about the soundness of the decision.
Thank you.
Any other question?
Next is page number 5 of this paper, is find that. And I do not find any provision in the Armed Forces to Special Power Act 1950 Act empowering the Armed Forces to interrogate any arrested person except handing over the person to the nearest police station in the manner provided by Section 5 of the Act. But we find the army personnel and paramilitary forces are interrogating the arrested persons without any authority of law and using third-degree matters filed in their custody for the purpose of extracting information leading to serious violation of human rights. It is frequently happening in Manipur, but here my question is that in such a juncture, what steps to be taken for prevention of such things done by the army personnel in contravention of the provision of the Armed Forces Special Power Act 1950?
The remedy available in such situation is only at the intervention of the court. We don't have any other remedy. We don't have any other tribunal. Because you will find it right from section 1 to section 6, you won't find anything empowering, because that power has not been given intentionally to them by the premise of this constitution. Reason why? They are not trained in the line, in the art of investigation. They are only just to meet a particular situation. They have been trained. They have been empowered to arrest and apprehend and handed over to the nearest police station, not to the extent of the law. Now, as you know, Mr. Rabai, since you are a local man dealing with this, such types of cases in Manipur, you must have come across 100% in all cases. There goes on interrogative acceptance. The case of this Mr. Max Pajam was a judicial officer of this case, and by the time he was grade 2 judicial officer, now grade 1 judicial officer, additional district judge. it's my friend also. Well, it shocks. It shocks the conscience of all human beings. I don't know how they react. I met that brigadier by the time. Unfortunately, he expired also. And in some party, we just casually he started talking about it, but I remained quite silent. Then I questioned it, how could we expect? How could we expect? Even if he renders help to this, according to them, according to the information, he rendered help to this Madhavan. True, he might have. True, he might have. But from this higher authority, I hope that this is the thing what your employee is doing. Doesn't do that. Instead of that, immediately High Court, after it would put that person under suspension. Instead of doing, you are doing your own law and unto yourself. So that's the matter so casually. And we come across the violation of the human rights case of this when I'm sharing. And that was caused by one of my colleagues from Delhi, Nandita Akshan. And she used to come very often, and I used to have a consultation and advise me that how to cross-examination all these witnesses. In some days I was present when their cross-examination was going on before the district Manipur. What was it? It was I think it was Mr. Upendra Vidya who made the inquiry. It took one's conscience. We never thought that such things, barbaric act could have been committed. Everything in the part of the world before dawns of civilization also. Because right from the beginning, right from the thoughts of a person in a society on the earth, and there was some basic thing of this reasonableness, human touch to all these problems. But they didn't have. Even to the extent of this, a pregnant woman was forced to give birth in the open. Could such things could ever be heard in this world society even today? This is the thing what is going on. But the people is yet to react on this matters. What I blame on today is not only the armed forces, but I blame myself and yourself, you all people. We have not made the people aware of these rights. This is the thing. Any other question which?
Sir, excuse me, sir. Sir, referring to your the particular sentence contained in page number 2, that human dignity is a dear value of our constitution and not to be battered away from mere apprehension by jail official. Sir, in numerous cases of human rights violation in the state, I believe that human dignity itself is battered away by mere compensation. Sir, such is not this practice itself a violation to our human dignity or violation to human rights?
Yeah, true. But the remedy available as of today. But the next step is to prosecute and then punish them according to the law of the land. And actions have been taken. This is the reason why the Supreme Court in Nalini Bela's case ordered for this investigation. Even in Sebastian Hungary's case, also ordered for investigation and proper investigation and book the culprits and punish according to law. Whenever such violation actual remedy available will be some amount of compensation, whether it is adequate or not, and next to punish according to the law of the law. This is accept this. There is nothing. It is not a question of burdening away. This is a question of giving some relief to the person who can afford, or who is maybe may not be sufficient, which can be given by the society, by the law. Then I think this will be my answer.
Sir, I also made allowed to join in this session.
Yes.
align towards one question. Kindly see page 3 of your book. In the middle portion.
Yes.
The armed forces of the Union consist of the army and other forces of the Union, such as Central Reserve Police Force, the Assam Rifles, Border Security Force, etc. Here I would like to know from you, on behalf of the delegates, that whether the armed forces includes the paramilitary forces.
Yes. Supreme Court as well as High Court has already interpreted that matter, that paramilitary are the forces of the Union. They are amongst the within the of other forces of the Union.
Thank you.
Even in our case, I have forgotten the citation. Also, this is the justice apprehensions. That's no problem.
The case of the judge who was tortured
Yes.
in 1989.
Yes, yes.
The report has been sent to the High Court in 94.
Yes.
And the case is pending before the High Court from 94 onwards.
Yes.
It's a contempt petition, so on the contempt petition of the High Court in respect to the torture of the judge. Is it possible for you to move to have that matter finally heard? That may be a very crucial.
Yes, it's possible. But it is possible. It is possible in my opinion. It isn't ever known. Because we are entitled to see that such protection is available not only. But when High Court is not administering justice to his own employees, what we feel, what I feel is that High Court, his service condition is controlled by the High Court in respect of these judicial officers. Then what a tragedy one has to face in the case of other general court. That you can visualize it. We can go for it. I think of it.
If you as a senior counsel can move the court and say that on behalf of the advocates we want this matter to be heard urgently.
Yes, that is also. That's all.
It will be a historic case, I think.
Yes, yes.
The report has come in favor of the judge.
Yes.
That he was tortured by the brigade.
And I am told that the person who is responsible brigadier probably had already expired.
No, he has retired.
No, after that.
He's expired, is it?
Yes. I was told.
No, when we met the judge today, he said that he has retired.
He has retired.
So if they get punishment of 6 months under the Contempt of Courts Act, that will be a historic body.
Historic, but our High Court, when such crime is committed of the highest degree, they are all employees. If they are not interested in punishing them, what more she think we will do also. But it's in the interest of justice. And
you
fairness
can
to all this public and if I offer to all this better in some organized groups in the case, I volunteer my service for that.
Actually, it's not only contempt of court, it is a patent offence under the Indian Penal Code. And the High Court should not only hold these officers guilty of contempt of court in as much as these officers have interfered in the administration of justice by taking him in this manner. The High Court should further sanction prosecution against the persons who are responsible for this. And why can't they do it? High Court should do it. Because that's the way. It's not merely contempt of court. Whoever it is, maybe the brigadier has expired, but there are other officers who were there. The army must give all the information. All of them should be prosecuted for what they have done to this particular judge. That's done.
This will be the last question from my side. I would like to know, on page 5 at the bottom, abuse of the provisions of Act 1950 Act causing disappearance of the persons taken into custody by the armed forces was brought to the notice of High Court by habeas corpus petition filed in the early part of 1981 for the first time. The case went up to the Supreme Court and the Apex Court directed the SP in part to investigate into the case and the compensation at rupees 1.50 lakhs, which paid to the paid to be paid to the
this is we are ordered to be paid.
Ordered to be paid to the mothers of the disabled person, and the fact of the case registered at Socio-Legal police station is not yet known. But here my doubt is that, sir, since the Supreme Court directed the SP Impal to investigate into the case that it was in the year 1997, by now 2000, then under the provision of the Contempt of Court Act, then the court disobedience of the Honorable Court order, then if it is to be filed contempt, it is to be filed within 1 year, so far the act is concerned. But my doubt is that should we file contempt, or should we file the test petition for such disobedience of the order of the Honorable Apex Court? This is my thought.
Mr. Ravi, your question is whether since 3 years has already been lapsed, whether still the court will action for filing the petition when the Contempt of Court Act provides for 1 year, petition is to be filed 1 year. Does it survive? I think that your question is this. Yes. In my opinion, my answer to this, that it survives. Because it will be a continuing cause of action, and investigation is a process which continues, and it is not one act which could complete it. It is a continuous process. And even though it is filed here, and it will survive.
Why the investigation is being on for many years together?
Years together, it is to be brought to the notice, and we have to ask them to expedite, and if it is not expedited, it will be willful disobedience of the court's order.
In addition to Mr. Ravi's question, I would like to know from the senior advocate that whether the said contempt may be filed before the High Court, because the matter is against the Supreme Court's order. So what is your view?
My view to that is, since the order arises out of the case, after the judgment is refusing by our High Court to entertain that petition, in my opinion also, that case could be filed here also. There are two distinctions between the case, which is contempt of the court itself, contempt of the order of the court. And this is a case of the second category of the contempt of the order of the court. Because it is not an order passed by the order of the High Court not to be that of the Supreme Court. On that theory, we can test that I have not come across the direct decision on that point, and of course subject to further study on that point. My answer will be that we can file directly here also, because this case arises out of the order in a habeas corpus petition here.
So, what is your opinion, sir?
I tell you, this is an order of the Supreme Court to investigate the case of company. I think, I don't know, it's possible, perhaps you may even file a case here, and then the High Court can direct I don't know whether the High Court will punish him for the contempt, but at least High Court will direct the officer to notice what's their answer for not investigating one. But in any case, you file to the Supreme Court, it's a clear case of contempt.
Supreme Court clear. But since what my reason is this, since the order has not been passed by the Supreme Court in exercise of this original jurisdiction, and the order is passed by in exercise of the appellate jurisdiction, in my opinion, this is the reason why.
Yes, we may try here.
Yes, we may try here also. I hope my paper has given some ground and some thought for discussion, and I'm very thankful to this organization for inviting me to participate, and I welcome the discussion also, and in future also I will all help.
which the organization prepared for sector. Thank you.
Thank you, Sri L. Nandakumar, for presenting us with the abuse and excesses of the Armed Forces Special Powers Act 1958 and its remedies. I hand over our next program to respected Sri H. Suresh, former judge of the Bombay High Court, for further discussions. Thank you.
There are many things I want to say. I think I'll say it later.
Next, I call upon Sri K.H. Mani Singh, Senior Advocate, to present his paper on the role of lawyers in defending human rights. Please, Sri K.H. Mani Singh.
Just a practical announcement before our Honourable Speaker takes over. The paper will be reaching us very soon. Our friends have gone to photocopy, but because of certain difficulties he had not reached, but we will make it available before the participants leave the conference. Thank you.
Thank you. Respected Mr. Chairperson and respected resource person, my brother Sri L. Nandakumar, Senior Advocate, ladies and gentlemen, friends, my paper is very simple regarding the roles of the lawyers in defending or protecting the human rights. Introduction. Every human being is entitled to certain natural rights by virtue of his being a member of the human society. These rights are called human rights. Human rights are those minimal rights which every individual must have against the state or other public authority by virtue of his being a member of the human society, human family, irrespective of any other consideration. Human rights, according to the Protection of Human Rights Act 1993, means the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. When human rights are guaranteed by a written constitution, they are called fundamental rights, because a written constitution is the fundamental law of the state or a fundamental source of the law of the state. Human rights and fundamental freedoms are the birthright of all human beings. Their protection and promotion is the first responsibility of the government of a state. Society and the state can alone guarantee human rights to the individual, but also demand observance of social norms from the citizens. Individual dignity is very essential for the viability of the society, but the human rights can be ensured only by a viable society, and the basis of the viable society must be democratic principles and the rule of law. The human rights were formally acknowledged and declared in realization of the need to safeguard and promote the inherent dignity of all the members of the human family. Right to personal liberty has been considered most significant of all the human rights. The human rights of personal liberty has been guaranteed as a fundamental right under Article 21 of the Constitution of India. In protecting and guaranteeing the human rights, the role of the state through its law enforcing agencies such as police and other security forces as administrative agents of the criminal justice is highly necessary. However, the role of the lawyer in defending the human rights and freedom is also highly necessary and important. My present paper highlights the importance of the human rights in the context of the role of the lawyers in defending human rights. The role of the lawyers in defending human rights. The lawyer is the greatest bulwark in defending human rights and freedom. The role of law and the lawyer in a civilized society is highly necessary. There can be no civilization without order. There can be no order without law. And I would like to add that there is no law without lawyers to interpret it. In spite of in spite of the diatribes, lawyers are indispensable to civilized society, more so when it is free and democratic. Every change and development in the society, in the social, political and economic order, every scientific discovery, every movement of people and things, and every act of the government involves the aid, guidance and the decision of the lawyer. So too, all agencies of the government, all corporations, companies, institutions, all occupations, including trade and commerce and voluntary organizations, also need the service of the lawyer, for their members have to be protected and governed by law. Sri Harilal J. Kania, the first Chief Justice of the Supreme Court of Independent India, observed the following, I quote, "Without law, no business can thrive. Without law, no society can survive. But at its base, advocacy with its honesty, its eloquence, and its sources has always been on the side of the weak and the just. For law is primarily concerned with the drama of life and its essential humanity. The whole drama of man's progress from savagery to civilization is the drama of law. His progress is the progress of law." Unquote. Again, R.S. Nayak, ex-Chief Justice, Andhra Pradesh High Court, observed, I quote, "No country can ever have a bright and a prosperous future unless the foundations of law and justice are well and truly laid, and the whole structure of the society is properly raised on such solid grounds. The greatness of any country and the high standard of civilization of the people, its people, is judged by the severity of the honor, life and property of its forest inhabitant." Unquote. The profession of law is a great and noble profession. Its continued existence is necessary forever, not only for the administration of justice, but for the functions of the democracy and rule of law. Members of the legal profession have rightly been called as the backbone of the justice in the courts of law. It is their fight for the cause they plead in the courts, including human rights violation cases, which stimulates even their worst critics to enthuse admiration for them. Lawyers are generally the defenders of human rights. The lawyer can play an important role in defending the human rights by his training and the position he occupies in the society. He is eminently qualified to undertake this task. He has the knowledge of substantive laws and legal procedure which his client does not possess. He has the right of appearance in court and the right to be heard by the court. The lawyer is usually a respected and privileged member of the society. As people look up to a doctor to protect their health, they look up to a lawyer to protect their rights, including human rights. In Sheila versus State of Maharashtra, writ petition criminal number so-and-so, 1982, dated 15/2/1983, the Supreme Court, by Bhagavati J. speaking for the court, held that, quote, the profession of law is a noble profession which has always regarded itself as a branch of social service And a lawyer owes a duty to the society to help people in distress, and more so when times in distress are when those in distress are women and in jail. Lawyers must realize that law is not a prison retreat where we are concerned merely with mechanical interpretation of rules made by the legislature, but it is a teaming up and a happening through which most of the traffic of human existence passes. There are many casualties in a spirit of dedication and service. It is for casual ties who still go without legal assistance. The lawyer must positively reason out to those sections of the humanity who are poor, illiterate, and ignorant, and who, when they are placed in a crisis as an accusation of crime or arrest or imprisonment, do not know what to do or where to go or to whom to turn. If lawyers, instead of coming to the reserve of person in distress, exploit and prey upon them, the legal profession will come into disrepute, and large masses of people in the country would lose faith in lawyers, and that would be destructive of the democracy and the rule of law. Unquote. It should be the next paragraph. After the introduction of the public interest litigation system in India by the Supreme Court, it has been possible to protect many of the human rights in the recent past. The initiative in this field was taken by the lawyer through the highest court of the land. In S.P. Gupta versus Union of India, which is a well-known public interest litigation, and the same is popularly called the judges transfer cases, being transfer case number so-and-so, number 1509 of 1981. Dated 30/12/1981, the Supreme Court held that the major impediment in bringing the problems of the underprivileged before the court and in the way of providing access to justice to the deprived and vulnerable sections of the society was the traditional rule of locus standi. Rejecting the contention of the government that the members of the legal profession have no locus standi to invoke the jurisdiction of the Supreme Court, Bhagavati J. held that any public-spirited individual can move the court in cases where the person concerned seeks judicial redress in the cause of justice, provided the person moving the court is acting in the interest of public and not for personal gain. And I repeat, not for personal gain, private profit, political motivation, or other public consideration. Bhagavati J. further observed, I quote, where a legal wrong or legal injury caused to a person or to a determinate class of person by reason of violation of any constitutional or legal rights, or any burden is imposed in contravention of any constitutional or legal provision, or without authority of law, or any such legal wrong and legal injury or illegal burden is threatened, and such person or determinate class of person is by reason of poverty, helplessness,